Hi everyone, it's me, Cal Sander, your travel-sized qualified legal advisor, here to help simplify and explain life's most common legal challenges. And today we're talking about your rights regarding work breaks and meal periods in the UK. The subject of rest breaks at work is one that continues to attract a lot of rumours and misunderstandings. The law is actually quite clear on this topic. And so in the next 10 or so minutes, I'm going to tell you exactly what rest breaks you are legally entitled to, how to get them, and what to do if your employer isn't complying with the law. Now, understanding these rights is essential for maintaining your health and work well-being, and that's important. Your job satisfaction is important and it will influence your mood and, by extension, your performance at work. So feel free to use the timestamps to navigate this video as it relates to your situation, and let's get straight to it. Let's first look at rest breaks during work hours. Now, in the UK, the basic rights to rest breaks are outlined in the Working Time Regulations 1998, which states that if you work more than 6 hours a day, you're entitled to a minimum 20-minute uninterrupted rest break during your workday. This break is meant to be taken away from your workstation, and you cannot be forced to take your break at your desk or workstation. Now, as for your daily rest breaks, either is between your shifts, you have the right to a minimum of 11 consecutive hours of rest between each workday. Now, there are also rules surrounding your weekly rest breaks, which state that you are entitled to either one uninterrupted 24-hour period of rest each week, or one uninterrupted 48-hour period of rest each fortnight. This means that you cannot be forced to work more than 6 days consecutively in 1 week. Now, these numbers may seem low to you, but it's important to remember that these are the statutory minimum requirements, but most businesses will go above and beyond this, so you shouldn't expect to only receive 20-minute break wherever you go. Employers, remember, they still have an obligation to protect your health and the well-being of their employees, and that would include making sure they are well rested, because if there was ever an accident at work due to tiredness as a consequence of overworking, the employer may be liable for personal injury compensation. Now let's consider some important exceptions to the rule which relate to specific types of worker, which you may be, so listen closely to this. Now, the law says that some types of workers are not entitled to specific rest breaks like we discussed before. You may instead be entitled to a compensatory rest break. For example, if you are a shift worker, such as a security guard or employed taxi driver or hospital staff, or any such role which requires there to be cover at all times on your shift, then you may instead be entitled to a compensatory break instead. Now, a compensatory rest break means you can take your break at a later time. It should be taken within a reasonable time for when you missed the break, and it should last as long as a specific rest break would have. And what about young workers? What about those under the age of 18? Well, according to the Working Time Regulations 1998, the rules here are slightly different. If you're under 18, over school leaving age, you have different entitlements. You're entitled to a 30-minute rest break if you work more than 4.5 hours a day. As for your daily rest between shifts, you must have a minimum of 12 consecutive hours rest between shift days. And as for your weekly rest, you are entitled to at least 48 hours off in any 7-day period, meaning that if you're under 18, you cannot be forced to work more than 5 days per week. Now, as for whether your work breaks are entitled to be paid or unpaid, the rules generally are that rest breaks during the workday are generally unpaid unless your contract states otherwise. Now, employers must ensure that these breaks are taken and must not include them as part of your working hours. So now you should be aware of the law surrounding rest breaks, depending on whether you are a standard employee, or a shift worker, or a young worker. Now let's look at steps you can take if your employer isn't playing ball and is violating these rights. Unfortunately, some employers have been known to reduce and remove an employee's legal entitlement to their rest breaks. This can be done in a subtle manner or just outright flouting of the rules. This is why it's important to know not only your legal entitlement regarding rest breaks, but also your basic employment rights. There is a relatively straightforward procedure if your employer is not paying ball and allowing you to take your rest breaks, which involves basically flagging the issue with management in a formal manner, submitting a written grievance if that fails, or finally going to an employment tribunal. So here is the full procedure. Ensure you don't miss any steps. Number 1, know your contract. Start by reviewing your employment contract to see what you are formally entitled to. Some contracts offer more generous break entitlements than the legal minimum. Understanding your specific terms can help you identify if your rights are being infringed. Number 2, document everything. Keep a record of any breaches by your employer of your rest break entitlements. Note down any dates, times, and relevant details. This documentation will be crucial if you need to escalate your complaint. Number 3, communicate with your employer. If you notice that your breaks are not being honoured, start by having an informal discussion with your employer or line manager. They might not be aware of the issue, and a simple conversation could resolve it. Next, write a formal complaint. So if an informal discussion doesn't resolve the issue with your employer, you can escalate it by writing a formal complaint. Now, outline the specifics of your problem, refer to your employment contract, and mention the relevant sections of the Working Time Regulations 1998, as I've mentioned to you. If that fails, the next compulsory step before tribunal is ACAS, the Advisory, Conciliation and Arbitration Service, which you may have heard of. It offers free and impartial advice on workplace disputes and can guide you on your rights and the best course of action to take. ACAS also offers a free early conciliation service which can help you resolve disputes without having to go to an employment tribunal. It's easy, straightforward and highly recommended, and I've provided the link to ACAS in the description below this video. Finally, if all else fails, you can take your complaint to an employment tribunal. This should be a last resort after exhausting all other options. The tribunal will assess your case and can enforce your rights if they find in your favour. Okay, so that's everything you need to know. Remember, understanding your rights regarding your work breaks and meal periods is crucial for your well-being and productivity at work. If your employer isn't respecting these rights, there are steps you can take to challenge them effectively. Start by reviewing your contract, document any breaches, communicate with your employer informally. If needed, escalate your complaint through formal channels and seek advice from trade unions or ACAS. That concludes the video. If you'd like to learn anything from this video, feel free to drop me a like or maybe even subscribe to my channel to ensure you have qualified legal advice in your back pocket at all times. That being said, see you in the next video.